So in the first week of land law, we looked at the distinction between proprietary and personal interests in land. But I said that there's a second major distinction to be drawn, and that's between legal and equitable interests in land. And I want to talk about that in this brief video. But I want to emphasise that both legal and equitable interests in land are equally proprietary. So when we talk about legal interests in land, we're not contrasting legal with illegal, but rather we're saying that this legal interest in land has been created in the way that's recognised by the common law. In the next slide I'm going to make the point that that means that it's been created by deed. And the difference is that an equitable interest in land has not been created by deed, has not been created in the way that's recognised by the common law, but it's been created in one of the additional ways that's recognised in equity only. But whether the estate or interest is legal or equitable, it's still proprietary. It's just the method of creation that's different, as I've just explained, and also for unwritten equitable interests there are different priority rules, as I'm going to introduce in a second. So legal estates are created by deed in order to comply with section 4 subsection 1 of the Conveyancing and Property Ordinance, and a deed is just a written contract which has the additional feature that it describes itself as a deed by, for example, beginning with the words "this deed." Equitable estates are not created by deed, and so they're not recognised at common law. But equity recognises some additional routes, some additional methods of creating estates in land. One is where the parties enter into an enforceable contract, but this contract does not describe itself as a deed. Secondly, where an express trust of land is created, where, for example, I own a flat in Ma and Shan, and I say, I now hold this flat on trust for my son. So this my son, as far as equity is concerned, is now the owner of the flat. His interest in the flat has arisen in this way that's unique to equity. And the third way is that there might be an implied trust of land. This could be a resulting trust or a common intention constructive trust. So it might arise because there's a spoken agreement between the parties that they're going to share the ownership of land, or the courts might infer a resulting or constructive trust from the fact that the party whose name is not on the title deeds has made financial contributions to the purchase price or to the payment of the mortgage instalments. Does the distinction between legal and equitable interests in land have any practical importance? The main practical importance is the different priority rules, but these different priority rules only apply to unwritten equitable interests, such as, for example, interests that arise under a resulting or common intention constructive trust, which arise out of some spoken arrangement or inferred from conduct, like making those financial payments I mentioned in the previous slide. These interests are proprietary and in principle do bind later interests in land, the owners of interests in land that arise later, but with one important qualification. An unwritten equitable interest does not bind a later purchaser for value of a legal estate in the same land with who has no notice of the earlier unwritten equitable interest. That person is called equity's darling. So unwritten equitable interests do not bind equity's darling. But the second bullet point here makes the point that where an interest in land is created in writing, it doesn't matter whether it's legal or equitable. The priority rules governing written interest in land created in writing, is always governed by the order of registration under the Land Registration Ordinance.